The applicant herein filed writ petition being WPC number 275 of 2012 before the Shillong bench of the then Guwahati High Court, praying for a mandate for payment of the said remaining sum of rupees 2 crore. Upon receipt of notice of the said proceeding, the Government of Meghalaya, through the Deputy Commissioner Ribhoi District, sought to annul the entire land acquisition proceeding, forcing the present applicant, being the writ petitioners, to file the second writ petition being WPC number 299 of 2012 before this Honorable High Court. Both the writ petitions were taken up for hearing, and by judgment and order dated 17/2/2014, passed in WPC number 299 of 2012, the following were observed, directed by the Honorable High Court. The learned Advocate General has further stated that the land was in possession of the government for the last 40 to 52 years. However, the learned Advocate General could not place any documentary evidence where from and how the land has come in the possession of the government. It was further informed to the court that a criminal case has been registered against a person involved in fraudulent practice. Just for a moment, Your Lordship. Now, against this judgment of the learned single judge, Your Lordship, the state had preferred a writ appeal. That is writ appeal number 20 of 2021. That has come to be dismissed, Your Lordship. I continue, Your Lordship. That the notice for intended annulment of the land acquisition passed by the Deputy Commissioner Ribhoi District, Nongpo, dated 8/10/2012 and 15/10/2012 were not in conformity with the provisions of the Land Acquisition Act, and hence both these notices were set aside. It was further observed that if the government was sure enough that the petitioner's claimants had taken payment of rupees 8 crores by fraudulent practice, then in that case they should file a recovery suit before the appropriate court, failing which the respondent government is directed to pay the remaining rupees 2 crores as agreed upon by the parties at the time of acquisition within 4 months from the date of receipt of the judgment and order, along with 9% interest, and thereafter 12% interest for each delay. That's the end of that Honorable Single Judge order, Your Lordship. Now, prompted by the said judgment and order dated 17/2/2014, money suit number 8 of 2014 was filed by the state of Meghalaya, being the plaintiff, against the humble applicants, herein being the defendant, praying for recovery of rupees 8 crores. The suit was filed on and around 13/6/2014. That on receipt of the notice from the court, the defendant's applicant herein filed an application under Order 7 Rule 11 of the CPC, praying for rejection of the suit on specific grounds enumerated in the said application, to which a show cause notice objecting to the said petition was filed by the plaintiff state. The matter being heard was finally decided by order dated 16/2/2016. This is the most important date, Your Lordship. 16/2/2016. The money suit filed by the state was rejected. The matter being heard was finally decided by order dated 16/2/2016 by the Learned Court of Assistant to Deputy Commissioner in High District, Nongpo, inter alia, holding that the suit was not maintainable in its present form, both for non-joinder of necessary parties as well as for one of cause of action, and being barred by law as provided under Clause A and D of Order 7, Rule 11 CPC, thus entailing rejection of the claim. That although the order dated 16/2/2016 was passed after hearing submissions of both parties in open court, an appeal against the said order dated 16/2/2016 was preferred by the state, being the appellant, before the Court of Learned Deputy Commissioner Judicial Nongpo, invoking the provisions of Rule 36A of the rules, albeit after a delay of 707 days. The said appeal, registered RFA number 1 of 2018, was accompanied by application for condonation of delay, being registered as Miss Case 2 of 2018, without, however, disclosing any provisions of law under which condonation of the admitted delay was being sought for. Now, this Memorandum of Appeal, Your Lordship, is annexed as Annexure 2. Then the following documents, Your Lordship, I will not come to those things, perhaps in later. I'll come to Para 6, Your Lordship. That the respondents in appeal, applicant herein, filed a show cause objection to the said application for condonation of delay, grounds and contents whereof would be pressed before Your Lordships at the time of hearing of this application. That the Honourable Appellate Court, after hearing the parties, was pleased to pass an order dated that the Honourable Appellate Court, that is the Additional Deputy Commissioner, after hearing the parties, was pleased to pass an order dated 15/6/2023, Annexure 1, inter alia, condoning the delay of 707 days by holding. This court finds that the intention of the applicant was bona fide. There was no deliberate inaction on the part of the applicant in taking up the matter, and they have not slept over their right or waived it, and it also shows that they are interested to pursue the matter. As such, this court finds that in the interest of justice, the delay of 707 days is hereby condoned. That on the aforesaid attending facts and circumstances apparent on the face of the record, this humble application challenging the order dated 15/6/2023 and the entire proceeding arising of RFA number 1 of 2018 and connected Miss Case number 2 of 2018 are put to judicial scrutiny of Your Lordships on the following amongst other grounds. Now I have to read the grounds, Your Lordship. For that, Rule 36A of the rules being self-contained code in itself providing an appellate jurisdiction upon the Court of Deputy Commissioner from the decision of an assistant filed within 30 days from the date of decision, excluding the time required for obtaining the decision, obtaining the copies, Your Lordship. Any delay beyond the statutory, beyond the stipulated date of 30 days is clearly barred under law, and hence the condoning delay of 707 days is ex facie without jurisdiction and liable to be quashed. For that, there being no provision or power granted to the learned court for condonation of delay, the order in appeal dated 15/6/2023 condoning delay of 707 days is patently unknown to law and hence liable to be quashed. For that, the so-called petition in Miss Case number 2 of 2018 itself is nonetheless in the eyes of law, having not even contained any provision of law under which such condonation and inordinate delay of 707 days was prayed for. It is not known as to under what provision of law the delay condonation petition was accepted, Your Lordship. A petition accepted, adjudicated, and ordered by the learned court, thus entailing as setting aside of the entire proceeding as well as the order dated 15/6/2023 passed therein. For that, the limitation prescribed under Rule 36A being final, and any power of condonation of even a day's delay beyond the stipulated period of 30 days being alien to the rules of 1937, the order dated 15/6/2023 has been passed absolutely without any statutory force, thus entailing setting aside of the said order dated 15/6/2023. For that, without any power for condoning delay, the ground of satisfaction derived by the court in passing the order dated 15/6/2023 are ex facie void, illegal, and thus rendering the order dated 15/6/2023 liable to be quashed. For that, even on the question of merit of the appeal, being RFA number 1 of 2018, the original order in appeal dated 16/2/2016, having been passed by the learned trial court in exercise of jurisdiction akin to and provided under Order 7 Rule 11 of the CPC, for which no appeal as such is provided under the appellate scheme of CPC. An appeal under Rule 36A is thus of no avail, to the appellant, rendering the appeal itself unknown to law. For that, neither the so-called application praying for condonation of delay is filed under any law invoking jurisdiction of the court, nor the same contain any ground so as to favor the appellant state with condonation of grossly inordinate delay of 707 days in preferring the so-called appeal. Hence, even on the facts that the order dated 15/6/2023 suffers from severe material irregularity apart from the lack of jurisdiction, warranting judicial scrutiny of your lordships. For that, the order dated 15/6/2023, although having been passed on the plea of interest of justice, has in fact occasioned gross failure of justice, thus meriting judicial interference of your lordship. For that, even otherwise, neither the so-called condonation petition contained any explanation for the gross inordinate delay of 707 days in preferring the appeal, which could have been condoned by the learned court on the plea of sufficient or even a good cause for condonation of delay, as held by the learned court, nor the appeal in RFA number 1 of 2018 contained any good ground warranting any interference with the original order dated 16/2/2016, rejecting the plain in money suit number 8 of 2014. For that, in any view of the matter, the order dated 15/6/2023, passed in miscase number 2 of 2018, arising out of appeal number 1 of 2018, referred to as miscase number 1 of 2022, and so and so, and the entire proceeding contained being prima facie an exercise to inflict injustice on your humble applicants, the said order dated 15/6/2023 and the entire connected proceedings are liable to be set aside and quashed. For that, these statements made by the respondent's appellant state in course of judicial proceeding before this honorable court in WA number 20 of 2021 and miscase number 66 of 2016, prima facie manifests the cavalier designs of respondent state to harass and drag the humble applicants in fruitless litigation so as to defeat the cause of justice, thus rendering the entire proceeding in money suit number so and so, appeal number so and so, as well as the connected proceeding in miscase number 2 of 2018, absolutely against the interest of justice, and thus qualifying for their quashment under Article 227 of the Constitution of India. Now, I just want to clarify on this point, Your Lordship, when I made a reference to Writ Appeal number 20 of 2021. It is in this petition, Your Lordship, which perhaps I may draw Your Lordship's attention. That is at it's annexed to the appeal before the lower court, Your Lordship. This is at, I have annexed it as annexure.
This is the appeal against the order which you have referred earlier.
This is this is the appeal against the judgment of the Honorable Single Judge, Lordship, and they have made a reference to this appeal, Your Lordship. This is appeal number 20 of 2021. This is at page 111, Your Lordship. This is part of the appeal before the lower appellate court, Your Lordship. Your Lordship is having. I may not waste the time with the court, but this is an appeal against the judgment and order dated 17/2/2014, passed by the learned single judge in WPC number so and so. I just draw Your Lordship's attention to a relevant paragraph, Your Lordship. That is at page 116, Your Lordship.
Yes.
At page 116. This is the statement of the state, Your Lordship, before this honorable court, before the division bench of this honorable court in this appeal, that without appreciating the legal infirmities in the judgment and order of the learned single judge in the judgment and order dated 17/2/2014, the appellants herein file a money suit before the assistant to the Deputy Commissioner Nepal for recovery of the paid amount of rupees 8 crores. this is one point that I want to point it out to the Honourable Court, Your Lordship. Without appreciating the legal infirmities in the judgment and order of the learned single judge in the judgment and order dated 17/2/2014, a suit has been filed, Your Lordship. Now I pointed out to another, that is at page 121.
By this order dated 17/2/2014, the
This is the judgment of the Honourable Single Judge.
the single judge has allowed the parties to file a money suit.
No, and I have already read, Your Lordship, those conditions, that the government does not have any documents to show that how.
That's
Those I have already read earlier, Your Lordship.
but it has also said if you have any grievance, you file a regular money
Yes,
suit.
yes.
So this is the order.
So
17/2/2014.
yes, this is the judgment, 17/2/2014.
This order was a sale in this
In this
writ appeal.
writ appeal, Your Lordship.
By whom? By you?
No, by the state.
By the state.
By the state, they have challenged the single judge order. It is the stand of the state
And in spite of that, simultaneously they have filed a money suit.
in spite of this appeal, they have filed an appeal against the judgment of the assistant to DC.
Okay.
What I wanted to say, Your Lordship, that without setting aside the order of the learned single judge, they could not have filed a money suit. That is the stand of the state,
what I
Your
was
Lordship.
saying.
That's the stand of the state, Your Lordship. Now, on the same footing, Your Lordship, this is on page 121. These are the grounds raised by them, Your Lordship, by the state. They cannot blow hot and blow cold. That is my case, Your Lordship. Page 121 at this number 7, Your Lordship, Roman 7. For that, the learned single judge acted illegally and with material irregularity by making diametrically opposite observation in the judgment and order dated 17/2/2014, inasmuch as even while setting aside the letters dated 8/12/2012 and 15/12/2012, thereby restraining the state government from withdrawing from the acquisition proceeding and purging the fraud occasion, Your Lordship. This is the allegation against the judgment of the Honourable Single Judge. The state government was directed to file a recovery suit before an appropriate court. You know. Now, the stand of the state, what does it say? Withdrawal from acquisition proceeding being a sine qua non for initiating any civil action for recovery of the money paid under acquisition proceeding. The learned single judge completely failed to appreciate the same, and the impugned judgment order dated 17/2/2014 being as such illegal and perfunctory is liable to be quashed and set aside. This is the stand of the state. They are saying that the procedure is some different, Your Lordship. If a money has been paid under Land Acquisition Act, Your Lordship, and the withdrawal from land acquisition, Your Lordship, or from acquisition is under that very act. And even for recovery of money, everything is under the Land Acquisition Act of 1894, Your Lordship. They could not have filed a money suit. This is a stand of the state before this court, Your Lordship.
So it's a court in itself, by itself.
Pardon, Your
It
Lordship?
is a court in itself,
Yes, Your Lordship. It's complete court.
providing all the procedures.
Yes, Your Lordship. There is honorable, due respect, Your Lordship, I may quote the name, Justice T.N.K. Singh, in one matter, he has made an observation that when we say court, it means the special judicial officer is a court in itself. It can, everything is provided under the Land Acquisition Act of 1894. My case here, Your Lordship, is that when they filed a writ appeal before this honorable court, Your Lordship, against the order of the learned single judge, this is their stand, saying that they could not have filed a money suit. It was they were wrongly advised to file a money suit, Your Lordship. I'm not bringing here the condemnation petition because it was already delayed at that point of time. In that condemnation petition, much worse observation was made by the state, Your Lordship. Now I come back to the main submission, Your Lordship. Okay. At page 15 of my petition, Your Lordship.
What was the order passed in this writ appeal?
the court division bench made several orders, Your Lordship, several observations which are very castigating upon the state government, and rejected the appeal against the judgment of the Honorable Single Judge, and at the same time imposed a cost upon the state, 1 lakh rupees, Your Lordship, 50,000 to be paid to the 50,000 to be paid to the Meghalaya Legal Services Authority, and 50,000 to be paid to us. That amount of rupees 1 lakh has not been fulfilled by the state till date, Your Lordship. It's some sort of a contempt, Your Lordship. I'll come to that later. My colleague is looking at it. I have not. I'll come to that later, Let me continue with my. I'm at page. I'm at page 15, Your Lordship. For that, the concept of condonation of limitation as provided under Limitation Act might be applicable in terms of such some available precedents in respect of dispute between non-tribals, which precedents are apparently not applicable in the present state. The dispute having involved tribals and the rights in this instant proceeding. Now, I'm still at page 15, Your Lordship. For that, the conduct of the appellant state.
But let us be clear, in proceedings, under the rules, the Limitation Act is not applicable.
Not applicable, Your Lordship. There's a judgment to this effect also, passed by the Honorable this Division Bench of this Court, Your Lordship, in a matter involving, I think, NIA, where my colleague made that submission that Section 29 of the Limitation Act comes into play. When there is a specific provision for provision for filing appeal, the question of exercising the Section 5 of the Limitation Act will not be applicable. That is Section 29, Your Lordship. Can I read that Section 29, Your Lordship, or not necessary?
Not necessary.
Okay.
But we are agreed that.
But I have cited the judgment, Your Lordship. For that, the conduct of the appellant state in appropriating and reprobating the issues involved in denial of justice as well as in the abuse of the process of law, thus meriting interference of Your Lordships under the constitutional jurisdiction of Article 227 of the Constitution of India. That the proceeding and order impugned, supra being prima facie illegal and without jurisdiction, being in denial of justice, the entire proceeding under RFA number 1 of 2018, as well as the effect of the order dated 15/6/2023, are liable to be stayed by Your Lordship pending. That is our stay application. Now, Your Lordship, before I continue further, I have made prayer for setting aside this judgment. I draw Your Lordship's attention to the application for condonation of delay, Your Lordship. That is at page 154, Your Lordship, Annexure 3. And before I continue to read Annexure 3 at page 154, just for cursory glance of this Honorable Court, Your Lordship may have a look at page 36, which is Annexure 2, Your Lordship, so that we do not miss the point, Your Lordship. Page 36, Annexure 2. This is the appeal filed by the state before the lower appellate court, Your Lordship. Just the cause title, Your Lordship. An appeal under Rule 36A of the Rules for the Administration of Justice and Police in the Khasi and Jantias. Just not to be confused, Your Lordship. This is an appeal under Rule 36A of the Rules of 1937. Now I come back to Annexure 3, Your Lordship, at page 154. This is accompanied along with the memo of appeal before the lower appellate court. An application for condonation of delay of 707 days in preferring the instant appeal against the order dated 16/2/2016, passed by Leonard Aston to Deputy Commissioner in this case number so and so. I will come to the main contents of their petition, Your Lordship, at page 155. that the applicant as appellant have preferred the connected appeal against the order dated 16/2/2016 passed by the Learned Assistant to Deputy Commissioner Nongpo is Miss Case number in Miss Case 12T of 2014, an application filed by the respondent defendant under Order 7, Rule 11 CPC in money suit number so-and-so, whereby the Learned Assistant to Deputy Commissioner Nongpo allowed the said Miss Case number 12T of 2014 and rejected the plaint in money suit number so-and-so on the ground that the plaint does not disclose a cause of action, that plaint suffers from defect of non-joinder of parties and the suit is barred by law. This is the state's application, Your Worship. That the applicant state that the applicant had instituted a money suit for recovery of an amount of rupees 8 crores, which was received by a respondent fraudulently claiming themselves to be the owner of land and trees in a plot of land situated at Maupalai, Ribohoi District, Meghalaya, whereas subsequently it transpired that the land in question is in possession of the Soil and Water Conservation Department, Government of Meghalaya, and the pine afforestation and coffee plantation therein, and the buildings and structure therein have been constructed by the Soil and Water Conservation Department from the public funds, and the respondents have no right to receive the land compensation for the same. The money suit number 8 of 2014 was instituted by the applicant pursuant to direction of the Honorable High Court, dated so-and-so, passed in WPC number so-and-so, Umsakwan Village Darbar and others versus State of Meghalaya and others, whereby the Honorable High Court has observed that if the government is sure enough that the petitioner claimant has taken payment of rupees 8 crores by fraudulent practice, then in that case they should file a recovery suit before the appropriate court. That the respondent defendant duly entered appearance in money suit number so-and-so and thereafter filed an application being Miss Case number so-and-so under Order 7, Rule 11 of the CPC for rejection of the plaint on the grounds inter alia that the plaint does not disclose a cause of action, that plaint suffers from defect of non-joinder of parties, and that the suit is barred by law. The said Miss Case number so-and-so was heard by the Learned Trial Court and white order dated so-and-so. The Learned Trial Court allowed the said application and rejected the plaint in money suit number so-and-so on the ground that the plaint does not disclose a cause of action, that plaint suffers from defect of non-joinder, and that the suit is barred by law. Now, that the applicant states that the aforesaid order was passed by Learned Assistant to Deputy Commissioner Nongpo on 16/2/2016, the counsel for the applicant obtained certified copy of the said judgment and order and forwarded the same, which was received by the Forest Department on 5/4/2016, Your Lordship. It's very important, Your Lordship. That the applicant state that after the receipt of the certified copy, the matter was processed at the level of the Forest and Environment Department and forwarded to the Department of Law for advice and legal opinion on 15/4/2017. Thereafter, on 21/4/2016, the Law Department opined that an order of the Assistant to Deputy Commissioner can be appealed before the Court of the Additional Deputy Commissioner and District and Session Judge Ribohoi District, and accordingly advised the Forest and Environment Department to contact the government pleader or any other advocate for drafting necessary appeal. Your Lordship may just pause for a moment. May I ask me, is this portion correct? That the applicant state that after the receipt of the certified copy, the matter was processed at the level of the Forest and Environment Department and forwarded to the Department of Law for advice and legal opinion on 15/4/2017. This is, they are making a very contradictory and very faulty statement, Your Lordship. In the earlier paragraph 4, Your Lordship, they say that the Forest Department received the certified copy on 5/4/2016 at para 4, Your Lordship. Yes. At para 5, they have forwarded to the Department of Law for advice and legal opinion on 15/4/2017. That is after 1 year.
I think this is a typographical error.
Could be, but we raised this point, they could have corrected.
The next line is
Yes.
It refers
We'll accept that, Your
it
Lordship.
refers to
Let's accept
2016.
Let's accept that. They could have corrected that point also. They did not. Thereafter, on 21/4/2016, the Law Department opined that an order of the Assistant to Deputy Commissioner can be appealed before the Court of the Additional Deputy Commissioner and District and Session Judge, Livoy District, and accordingly advised the Forest and Environment Department to contact the government pleader or any other advocate for drafting necessary appeal. I'll come to the next point of the petition, that the applicant states that thereafter on 13/5/2016, the Forest and Environment Department, after consultation with the Law Department, decided to seek legal opinion from another counsel on the matter. Why they wanted to consult another counsel, that is not disclosed here, Your Lordship. That is one point that creates a serious doubt, Your Lordship. The said counsel, in his legal opinion dated 13/5/2016, opined that an appeal against the judgment and order dated 17/2/2014, passed by the learned single judge in WPC number so and so, should be filed, bringing all facts of the instant case to the notice of the High Court, and also to pray for an investigation by the neutral third party to remedify the entire situation. That the applicant states that thereafter on 18/5/2016, the Forest and Environment Department, after obtaining approval from the Law Department, decided to appoint the said counsel as special counsel to appear on behalf of the Forest and Environment Department and to prepare a draft appeal against the judgment and order dated 17/2/2014, passed by the single judge. Let me read again paragraph 7, Your Lordship. That the applicant states that thereafter on 18/5/2016, the Forest and Environment Department, after obtaining approval from the Law Department, decided to appoint the said counsel as special counsel to appear on behalf of the Forest and Environment Department and to prepare a draft writ appeal against the judgment and order dated 17/2/2014, passed by the single judge in WPC number 299 so and so. On 25/5/2016, the said counsel was appointed as special counsel for Forest and Environment Department. Just to be clear, Your Lordship, the reference in this case to special counsel, not my colleague here, Your Lordship. It's not a person. Mr. Kipol was the lawyer, was appointed as special counsel. Okay. That the applicant state that thereafter on 8/6/2016, the Forest and Environment Department forwarded the comments and grounds of filing writ appeal to the said special counsel and requested the counsel to prepare draft of writ appeal along with application for continuation of delay. The learned counsel then prepared a draft of writ appeal along with application for continuation of delay and forwarded the same to Forest and Environment Department on 11/7/2016. Thereafter, the Forest and Environment Department forwarded a draft writ appeal to the concerned branch for verification and vetting of correctness of factual aspect the writ appeal. After verification and vetting, the Forest and Environment Department then forwarded the approved memorandum of appeal to learned counsel on 8/7/2016. Your Lordship, just for a moment, para 7 and para 8 is not relating to a matter in so far the judgment, the order passed by the assistant to the DC, Your Lordship. It refers to a different subject altogether. It could writ appeal, Your Lordship. It could not have been
order passed in the writ petition.
Yes, Your Lordship. These are all redundant, Your Lordship. That the applicant states that thereafter the conducted writ appeal along with the application for continuation of delay of the impugned judgment and order dated 17/2/2014 were filed before the Honorable High Court of Meghalaya on 27/7/2016, and the same was registered as Miss Case number so and so. The said writ appeal and the application for continuation of delay are pending disposal before the Honorable High Court. In fact, I can provide a copy for the Honorable Court perusal, Your Lordship, Alicia. The judgment and order was passed on 9/2/2022. After the said writ appeal was filed, the applicant was of the belief that necessary steps have been taken in the matter and appropriate proceeding has been instituted. As such, there is no further requirement of filing an appeal against the order dated 16/2/2016, passed in mixed case number 12T of 2014. So when we read 7, 8 and 9, Your Lordship, of that application, it is clear that the subject of that 7, 8 and 9 is referring to writ appeal, Your Lordship. That the applicant state that in the meantime, the respondent instituted money suit, being money suit number 4 of 2016.
Respondent.
This is filed by us, Your Lordship. We file a money suit.
Or you file a money suit.
That the applicant state that in the meantime, the respondent institute.
You file money suit or for that 2 crores?
For the 2 crores, Your Lordship. That suit has been decreed, Your Lordship, just on the sideline. Suit decreed on 10/8/2017, Your Lordship, along with interest, etc.
No contest.
No, restoration petition was filed. That also was rejected, Your Lordship. There was no further contest, and that point is reflected in the judgment of the division bench, Your Lordship. That fact, Your Lordship. That the applicant state that in the meantime, the respondent instituted a money suit, being money suit number so and so, against the appellant in the court of the Assistant to Deputy Commissioner, Riboi District, for recovery of the remaining amount of land compensation of rupees 2 crores, along with interest 18% per annum. The learned Assistant to Deputy Commissioner, Riboi District, passed an ex parte decree dated 10/8/2017, allowing the money suit with a direction to the appellant to pay the sum of rupees 2 crores to the defendant. I'll just pause here for a moment, Your Lordship. Before instituting the suit for recovery of 2 crores, Your Lordship, we have issued a notice under Section 80 CPC to the state. And at the time of filing of the suit also, Your Lordship, a copy was served upon the then government pleader at Nongpa. So this remark here that it was an ex parte decree was not correct. And during the proceeding of that suit, Your Lordship, it was referred to Lok Adalat, and my former district and session judge, Your Lordship, Mr. Khan, was at Nongpa at that time. He had referred this matter to Lok Adalat, and notice was issued to the state government, and they have written back that they are not interested to come and appear. It's all part of the evidence, Your Lordship. Yeah, they don't want to come and appear, and they want to attend some other official duties. That is on record, Your Lordship. Now I come back to the next paragraph 11. That the applicant states that since the said decree was passed ex parte, the applicant have filed an application on under Order 9, Rule 13 CPC for setting aside the ex parte decree, and the same is pending disposal. So I just want to bring to the knowledge of this Honorable Court, Your Lordship, the restoration petition rejected on 16/4/2019 as not maintainable. There was no appeal to that. It has attained finality. That the applicant states that in the meantime, while the application under Order 9 Rule 13 for setting aside the ex parte decree dated 10/8/2017 is pending before the court of the learned Assistant to Deputy Commissioner, the applicant again decided to seek legal opinion from a senior advocate in the matter. So Your Lordship can notice here that only after we have filed a suit and obtained a decree, then they jump and decided to file the appeal before the lower appellate court. That means it was an appeal as an afterthought, Your Lordship. The learned senior advocate, adverting to the fact that no appeal has been filed against the order 16/2/2016, passed in Miss Case number 12T of 2014, tendered the opinion that an appeal must be immediately filed against the order dated 16/2/2016, passed in Miss Case number 12T 2014. Even though a writ appeal has already been filed against the order dated 17/2/2014, passed by the single judge in WPC number so and so. That the applicant states that thereafter on 11/1/2018, the Forest and Environment Department, after obtaining approval from the Law Department, appointed the senior advocate as special counsel to appear on behalf of the Forest and Environment Department and to prepare a draft appeal against the order dated 16/2/2016, passed by the learned Assistant to Deputy Commissioner and Nongpo. This case number so and so. it is at this stage, Your Lordship, where my colleague came into the picture, Your Lordship, that the applicant states that thereafter on 12/1/2018, the Forest and Environment forwarded the comments on the grounds of filing the appeal to the Senior Special Counsel and requested the Counsel to prepare a draft of the appeal along with the application for condonation of delay. The learned Counsel then prepared draft of appeal along with the application for condonation of delay and forwarded the same to Forest and Environment Department on 25/1/2018. Thereafter, the Forest and Environment Department forwarded the draft appeal to the concerned branch for verification and vetting of correctness of the factual aspect in the appeal. The Forest and Environment Department then forwarded the memorandum of appeal to the learned Senior Counsel on 13/2/2018 for filing in the court, and same were filed before this court. I come to the most important factual aspect, Your Worship, that the applicant state that the judgment and order was passed on 16/2/2016 and a certified copy of the same was received by the applicant on 5/4/2016. There is no explanation as to what transpired in between 6/2/2016 and 5/4/2016, Your Honor. There is no explanation. As such, counting from the date of passing the order, the appeal ought to have been filed on or before 16/3/2016. This is, they have correctly stated, Your Lordship. And counting from the date of knowledge, the appeal ought to have been filed on or before 5/5/2016. Yeah, this maybe they have correctly admitted, Your Lordship. However, due to the circumstances as stated above, the appeal could be filed only on 23/2/2018, and thereby a delay of 707 days has caused if counted from 16/2/2016, and a delay of 658 has been caused if counted from the date of knowledge 5/4/2016. Now I come to the next point, Your Worship, that the applicant states that the delay is not intentional but due to circumstances as stated above, which was occasioned to the bona fide belief that the remedy of filing appeal against the judgment and order 17/2/2014 passed in WPC number so was the proper remedy. It was only subsequently that on the legal opinion tendered by the Senior Special Counsel that the applicant realized that the proper remedy is to file an appeal against the order dated so passed in this case number so. That the applicant states that the applicant has been diligently pursuing the matter, and the Forest and Environment Department is an impersonal machinery acting through its officers, servants, after obtaining legal opinion from Government Counsel and in appropriate special counsel, and the decision is taken and approval obtained through the administrative hierarchy on the basis of legal opinions of the Government Counsel and the Special Government Counsel. That the applicant further state that the matter involves that is not relevant, Your Lordship. What is more important, Your Lordship, there is no explanation as to, they have to give a day-to-day or month-to-month explanation, Your Lordship. They just cannot, even if you have to admit that Section 5 of the Limitation Act, they have to give sufficient cause, Your Lordship. In this case, I am saying that Section 5 of the Limitation Act is not applicable. Rather, Section 3 will be applicable, Your Lordship, of the Limitation Act. And in this case, it is my case, Your Lordship, that it is not applicable. And we file an objection to this application, Your Lordship, which is very relevant for me to read it over to this Honorable Court, which is on Annexure 4, page 162.
164.
162. 162. Show cause objection to the application for condonation of delay in filing an appeal. That the application for condonation of delay itself is misconceived and not permissible under law. It is not mentioned in the application as to under what provision of law the said notification has been filed. That it is well established principle of law that this Honorable Court, while exercising its jurisdiction vested under Rule 36A of the Rules for Administration of Justice and Police in Akasi and Jante Hills 1937, acts strictly within the confines of the said rules. Rule 36A clearly stipulates a period of 1 month for purpose of filing any appeal from an original decision of an assistant, provided that the said appeal is filed within 30 days from the decision, excluding the time required for obtaining a copy of the decision. The said rule of 1937 is a self-contained code in itself. The jurisdiction derived under the said rules have to be exercised in a manner provided in the rules, only or not at all. The rules have not vested any power for continuation of delay. The rules being one of those self-contained statutes like the Representation of People's Act 1951, I can add at this stage an IA also, Your Lordship, and other such statutes. There is no power to condone the delay in filing an appeal beyond the specifically mandated period within the framework of the rules, as well as a provision as to how to compute the said period. Hence, this application filed by the appellant is alien to the provisions of law and deserves to be rejected outrightly. That no court of law has got any inherent power to consider condemnation of delay in entertaining any application, suit or appeal if the same is filed beyond the period of limitation (time) prescribed by the statute under which such suit or appeal or application is filed. The jurisdiction to consider condemnation of delay must be specifically borne out of statutory provisions, and any litigants praying for condemnation of delay, that too of almost 2 long years, must file such petition specifically mentioning the provisions of law under which the exercise of jurisdiction of any court, more so a court of civil jurisdiction, is sought to be invoked. Hence, this application under answer needs to be rejected. That even assuming but not considering that the application for condemnation of delay can be taken up for disposal on merit, the following cardinal principle of law has to be borne in mind: that the state as a litigant is not posted at a higher pedestal than that of a common litigant. If the statute has prescribed a fixed period for preferring an appeal, it is the bounden duty of the appellant to scrupulously describe as to on which date what happened justifying the delay. In the instant case, paragraph 4 of the application simply say that certified copy of the order passed on 16/2/2016 reached the Forest Department on 5/4/2016. This statement, even if assumed to be correct, does not have any relevance under law whatsoever, in as much as this honorable court under law is empowered only to consider the period acquired for obtaining the certified copy of the decision, while computing the period of 30 days within which any appeal has to be filed. It is also not stated anywhere in paragraph 5 of the application as to what transpired between 5/4/2016 and 15/4/2017. It is also not understood as to how Law Department could opine anything on 21/4/2016 when the matter was forwarded to Department of Law for its legal opinion only on 15/4/2017. This is could be typographical, Your Lordship, but still I'm raising this point. As claimed in paragraph 6 of the application, it is not discernible as to how the facts stated in the subsequent paragraph 7, 8, 9, 10, 11, 12, 13, 14 and 15 in any manner justify the inordinate delay of 707 days caused in filing the appeal beyond its statutory period. None of the statements made in these paragraphs of the application of the applicant in any view of the matter constitute any ground for condemnation of the inordinate delay of 707 days. Further, the facts stated in paragraph 5 of the application and its subsequent paragraph are inherently self-contradictory and not fit to be relied on in any judicial proceeding. The proverbial bureaucratic lethargy in movement of files and decision-making process do not serve as any ground for condoning delay, even if the same power of condonation is in a given case is available under law. That paragraph 17, 18, 19 of the application are absolutely misplaced, and the same are in fact prima facie contrary to facts as evident on the face of the records. That a constructive application of Rule 41 of the Rules for Administration of Justice and Police in Khasi and Jetta Hills, 1937, depict the intention of the rule maker not to subject persons belonging to scheduled tribe of the state to the rigors of law of limitation, and also not to prejudice the cause of scheduled tribe even on the application of principles thereof. On the other hand, the state being a non-tribal litigant has to be subjected to strict rule of limitation, Your Lordship. Thus, by the application of Section 3 of Limitation Act, the appeal being beyond the prescribed time, statutorily mandated, the same is liable to be rejected, as the same being filed beyond the prescribed period under the statute. That it is reiterated that in the absence of any visible empowerment of condonation of delay by any provision of statute, the appeal is absolutely non-mentionable and the period of delay cannot be condoned. Your Lordship, at this stage, I will draw Your Lordship's attention to the Annexure 1, the judgment, the order passed by the lower appellate court, Your Lordship. On the last occasion, Your Lordship, I had opened up a submission by reading this particular Annexure 1 judgment, and I will avoid the submissions of parties. I'll come to the findings of
only the relevant portion.
Yes, the relevant. At para 18, Your Lordship, at page 29. This court noted that the applicant has filed the application without citing any provision of law for condonation of delay, and the learned counsel for the respondent has raised objection that any litigant praying for condonation of delay must file such petition specifically mentioning the provision of law under which the exercise of jurisdiction of any court is sought to be invoked. The learned counsel for the applicant submitted that the instant application has been filed under provision of Section 5 of the Limitation Act, which is not correct, Your Lordship, which is the only statute which provides for limitation and condonation of delay and which is applicable to the entire state of Meghalaya as held by the Honorable High Court. Though Section 5 of the Limitation Act 1963 is not specifically mentioned in the cause title of the instant application, but non-mentioning of the provision of law is immaterial as long as this Honorable Court has the jurisdiction. In this regard, reliance is placed on so and so, Your Lordship. I'll not take the time to just okay. I'll come to para 19, Your Lordship. It's cited on decision of the Supreme Court. On the other hand, the main contention raised by the senior counsel for the respondent was that there has been no reasonable explanation by the applicant as to how and why it took more than a year for the applicant to file the appeal after 707 days. The application for condonation of delay filed by the applicant is in respect of the application for appeal filed by the applicants under Rule 36A of the Administration of Justice and Police Rule 1937, which clearly stipulates a period of 1 month for the purpose of filing any appeal from an original decision of an assistant from the date of decision, excluding the time period for obtaining a copy of the decision, and this court has no power to condone the delay in filing the appeal beyond the specifically mandated period within the framework of the rules, as well as a provision as to how to compute the said period. Para 20, Your Lordship. The applicants claim to have filed the application under provision of Section 5 of Limitation Act 1963. I have already drawn Your Lordships to Annexure 3, where there is no mention of any provision. That's my main plank. Now the court has just brought it by itself, Your Lordship. Which is the only statute which provides for limitation and condonation of delay, and which is applicable to the entire state of Meghalaya as held by the Honorable High Court. And the question that arises for consideration before this court is as to whether the Limitation Act has any application to appeal filed under statutory provisions of Rule 36A of the Administration of Justice Rule 1937. Rule 36A of the Administration of Justice Rule 1937 provides appeal and revision. The High Court or Deputy Commissioner may, on application or otherwise, call for the proceedings of any case decided by any officer subordinate to him and pass such order as may deem fit. The Deputy Commissioner shall be a court of appeal from the decision of an assistant. The High Court shall be a court of appeal from an original decision of a Deputy Commissioner, if the value of the suit to be rupees 500 or over, or if the suit involves a question of tribal right or customs, or of right to or possession of immovable property, provided that the petition of appeal, accompanied by a copy of the order appeal against, and by clear statements of the ground of appeal, to be filed within 30 days from the date of decision, excluding the time required for obtaining a copy of the decision. An appeal which lies to the High Court may be presented to the Deputy Commissioner, who shall, if it be in order and presented in due time, endorse upon it the date of receipt and transmit it with the records the case to the High Court. The decree of the appellant court shall be transferred to so-and-so. Now, I come to section 5. Extension of period in certain cases. Any appeal or any application other than an application under any of the provisions under Order 21 of the Code of Civil Procedure 1908 may be admitted after the prescribed period if the appellant or the applicant satisfy the court that he has sufficient cause for not preferring the appeal or making the application within such period. It is observed that there can be no doubt that a special period of limitation has been prescribed for appeals under Rule 36A of the Administration of Justice Rule 1937, whereby it provides that the petition of appeal accompanied by a copy of the order appeal against and by a clear statement of regard be filed within 30 days from the date of decision, excluding the time required for obtaining a copy of the decision. The question is, we come to the most important point here. Para 22, the court, lower court admitted it has to be filed within 30 days. Now at Para 23, the question is whether the provisions of Section 5 of the Limitation Act can be invoked in aid of the applicant appellants for extending the time for filing the appeal under the aforesaid rule. This court has observed, I come to the most important point, Your Lordship. What wrong has the lower appellate court committed? This court has observed that the administration of justice and police in the Khasi and Jaintia Hills 1937 was enacted by the state government and published White Notification number so-and-so, Act number so-and-so of 1972 with effect from 22 to 1972 and is applicable to the whole of United Khasi and Jaintia Hills district, excluding the areas which were known as the Khasi state before the commencement of the Constitution of India for the trial of a particular case or particular cases, civil and criminal in the state. Therefore, it can be understood that the rule is a state law. This is a glaring irregularity, Your Lordship, committed by lower court. This is not at all a state law. This is a law of 1937, Your Lordship. There is a judgment of Ratan Singh before the Supreme Court. I'll come to that later, Your Lordship. Grievous error has been committed by the lower appellate court, Your Lordship. Now I come to Para 25. As provided in the Constitution of India under Article 254, if there is a conflict between the Central Act, Limitation Act 1963 herein, and the state law, the Central Act shall prevail. Taking into consideration that the Limitation Act is applicable in the entire state of Meghalaya, as held in the case of number so-and-so, that is my case, Your Lordship, Shara Action Committee versus State of Meghalaya. Therefore, the application for condonation of delay filed by the applicant is deemed to be within Section 5 of the Limitation Act, 1963. For exercising of discretionary power to condone the delay, the court can entertain any application should be in the absence of a formal application. Section 5 enables a court to admit an application or appeal if the applicant or the appellant, as the case may be, satisfy the court that he has sufficient cause for not making the application or preferring the appeal within the time prescribed. There is no bar to exercise by the court of his discretion to condone the delay. In the absence of formal application as held by the Honorable Supreme Court in so-and-so, Sheshnat Singh versus so-and-so. As such, this court has to look for the sufficiency of the cause of the inability of the applicant to approach the court within the time prescribed by limitation. The second issue for consideration is whether the applicant has any sufficient cause in filing the application for condonation of delay in preferring the appeal. As indicated above, learned counsel for the applicant in the condonation application has categorically stated that the ground as to why the appeal could not be filed within the prescribed time limit. The learned trial court has rejected the plaint of the applicant on the ground that the plaint does not disclose the cause of action, non-gender parties, and the suit was barred by law, while impugn order dated 16/2/2016. The applicant obtained a certified copy of the said judgment order, and the same came to the knowledge of the said impugn order, and same came to the knowledge on 5/4/2016. The matter was routed from the applicant's department to the Department of Law and has also sought for legal advice and opinion. As submitted, the applicant had also approached the Honorable High Court of Meghalaya on 27/7/2016 by way of writ appeal against the order of single judge order dated so-and-so for necessary investigation by a neutral third party to remedify the entire situation. However, the Honorable High Court refused to interfere the order of the Honorable Single Judge, as the applicant have accepted the said judgment and order dated 17/2/2014 and have accordingly filed a money suit in question number so-and-so for recovery of money. After filing of the writ appeal before the Honorable High Court on 27/7/2016, the applicant appears to have slept over his right in filing the appeal against the impugn order dated 16/2/2016. This is a good observation, Your Lordship, of the lower appellate court. The applicant appears to have slept over his right in filing the appeal against the impugn order dated 16/2/2016. The learned counsel for the applicant has argued that the applicant was of firm belief that necessary steps have been taken in the matter and there was no requirement to file an appeal before this court. It was only on 11/1/2018 the applicant realized that an appeal is required to be filed against the impugn order dated 16/2/2016. Thereafter, the matter was discussed and the same was routed for filing the appeal after obtaining obstruction and approval through administrative hierarchy of the department and legal counsel. Generally, the Limitation Act empowers the court to exercise discretionary powers to condone the delay only when the aggrieved party can show sufficient cause of not preferring an appeal within the time limit. The same becomes time barred if there is negligence, deliberate or gross inaction or lack of bona fide on the part of the party or its counsel. In Sri Devi Datla versus Union of India, reported and so, the Honorable Supreme Court observed that generally delays in preferring appeal are required to be condoned in the interest of justice, where no gross negligence or deliberate inaction or lack of bona fide is imputable to the party seeking condonation of delay. On careful perusal of the application for condonation of delay, this court finds that the applicant has taken up the matter with due diligence. The applicant received knowledge of the impugn order on 5/4/2016 and communicated the same to the law department. The applicant had also thought of an alternative remedy, thereby decided to file writ appeal against the order of the single judge. From the averments made in the application, it appears that the applicant's department had sought legal opinion or advice from many legal counsels, including the law department. In this case, Your Honor, this is the concluding part, and circumstances which are placed on record indicates that the applicant department took the decision. The other department had placed the matter for discussion, and the matter was again forwarded for consideration and consultation, prepared notes and drafts, and took decision. Since the matter had moved horizontally and vertically till it gravitates towards conclusion, the same can be considered as a good cause for condonation of delay. This court finds that the intention of the applicant was bona fide. There was no deliberate inaction on the part of the applicant in taking up the matter, and they have not slept over the right or waive it, and it also shows that they are interested to pursue the matter. As such, this court finds that in the interest of justice, Your Honor, the delay of 707 days is hereby condoned. Now, my case here, Your Lordship, as I have submitted earlier, my petition, that the order of the learned lower appellate court, Your Honor, is bad in law. It's absolutely bad. The rule of 1937 is not a state law, Your Lordship, and it is just there was an adaptation. I admit to that. In 1972, when you got a full-fledged state, it was adapted. There are many laws which have been adapted. It doesn't mean because it has been adapted, it becomes a state law.
What is the import of the process of adaptation?
No, it's just it adopts. It remains the same.
It remains the same.
It remains the same, Your Lordship. Now I'll come to.
It doesn't create any new law.
No, it does not create any new law. It remains the same, Your Lordship. Now, when the statute has prescribed 30 days, it cannot be beyond 30 days, Your Lordship. Even Section 5, as I've submitted earlier, does not come into play. I may just read the Section 29 of the Limitation Act, Your Lordship, and this was Limitation Act. This was quoted by my colleague, Your Lordship, in a case involving NIA, where there is a specific period for filing bail application. Section 29, Your Lordship. Where any special or local law prescribed for any suit, appeal, or application a period of limitation different from the period prescribed by the schedule, that means this schedule, Your Lordship, the provisions of Section 3 shall apply as if such period were the period prescribed by the schedule, and for the purpose of determining any period of limitation prescribed for any suit, appeal, or application by any special local law, the provisions contained in Section 4 to 27 inclusive shall apply only insofar as to the extent to which they are not expressly excluded by such special or local law. And it is my submission, Your Lordship, that a specific period has been prescribed under the rules of 1937. The question of invoking Section 5 of the Indian Limitation Act by the lower appellate court, suo motu, doesn't arise, because the application is not under any provision of law. It was a blank application, Your Lordship. I have got a number of precedents, Your Lordship, and it will take quite some time, Your Lordship, and perhaps I'll make a reply after my colleague has concluded this submission, Your Lordship. I'll come to the precedents later, Your Lordship. I'll come to the precedents later.
Your whole case is only on point of law.
Exactly, Your Lordship.
That Limitation Act,
and that there is no sufficient cause also.
Limitation Act is not applicable in the for the fact that the rules of 1937 are invoked.
Yes, Your Lordship.
What's the next?
Next page, Lordship. My Lord, this matter, the present controversy arises from land acquisition. Lordship seen that, my Lord. My Lord, this was a land near Sumer somewhere, my Lord, and this was a plot of 178 hectares of land where Zoom cultivation Department of Assam government, and then before creation of state of Meghalaya, they maintained the plantation, my Lord. And after creation of state of Meghalaya, all properties belonging to state of Assam by succession come to the state of Meghalaya, my Lord. Now, since 1972, that plot of land was under the control and supervision of Soil and Conservation Department, Government of Meghalaya, my Lord. They've raised their coffee plantation and several construction from the government money, my Lord. Now, for certain project, for a protected forest, my Lord, land was required by the government, and because of some oversight, my Lord, because this falls in River district, I think. So when the land acquisition, the Revenue Department of Nongpo, my lord, they notified this plot of land, and the petitioner appellant before a lordship, they posing themselves as the owner of the land, they came and received compensation, my lord. The agreed compensation was 10 crore rupees, my lord, and the land acquired was about 92.44 hectares. The entire land was not acquired, only 92.44 out of 178 hectares of land was acquired. This came to the notice of government later on, my lord. I'll just take your lordship to that particular document, my lord. My lord, kindly come to page 67, my lord. Page 67, lords, you will see this is the letter dated 28th May 2012 from Srimati ACM, Under Secretary to Government of Meghalaya Soil and Water Conservation Department, to the Principal Secretary, Forest and Environment, Establishment of Mopalai Protected Forest, number so and so. In inviting a reference to a letter cited above to the subject, I am directed to furnish below the requisite information as called for. Area of plantation is 178 hectares. Date of creation and age of plantation. The plantation was created in different years starting from 1959-60 to 1972-73. Hence the age of the plantation ranges from 40 to 52 years. Current status of the land is still in possession of the Soil and Water Conservation Department. Number 4, date of handing over does not arise in view of serial number so and so. Now, because of this, my lord, your lordship kindly turn to page 68, my lord, now.
Yes.
When this was discovered, my lord, the Deputy Commissioner wrote a letter to the appellant. This is the LEC, my lord, S.W. Rimbai, landowner, general power of attorney holder. Land acquisition proceedings in connection with the Mopalai Protected Forest. With reference to the subject cited above, it has been reported by the Forest Department that the plantation in Mopalai is still in possession of Soil and Water Conservation Department, and they were maintaining it for the last 40 to 52 years. Therefore, the land acquisition proceedings for the said plantation has to be quashed, and payments made to you amounting to rupees 8 crore needs to be recovered immediately. Therefore, you are requested to refund the above mentioned amount, failing which action may be taken as per Bengal Public Demand and Recovery Act for recovery of the amount. So when it was discovered, my lord, that this land which has been acquired, for which that they were collected compensation, they belongs to the government itself. So faced with the situation, my lord, the matter somehow came before this honorable court, my lord. My friend is referred to the order passed by Justice Sen, my lord, at that point of time, saying that state, you go and file a money suit. Now against this order, my lord, at that point of time an appeal was filed before the division bench of this honorable court. But during the pendency, as has been pointed out, when they contacted us, they also filed a money suit, my lord. And the division bench, lots of you seen the order. I'll just point out because this will clarify many things, my lord. I'll just refer to para 14, my lord. Para 14 and then para 17.
Yes.
Para 14. As far as present matter is concerned, it is evident that the appellants accepted the impugned order and acted in terms thereof. Inter alia, by filing the suit for recovery of the money, it is elementary that no litigant may approbate or reprobate in the same breath or in respect of the same cause. Indeed, upon the appellants having accepted the order and having instituted title suit number so and so, in fact, money suit, my lord, and before the relevant court at Nongpo, the appellants herein could not be seen any longer to be persons agreed by the relevant order to be entitled to prefer or pursue an appeal therefrom. In addition, the appellants herein have accepted the rejection of the plaint in their suit, or at any rate such a rejection has attained finality upon the appeal from the order of rejection of the plaint not being pursued by the appellant. The attempt of readmission of appeal appears to be cosmetic. Para 17, my lord. For the reasons aforesaid, and the appellants cannot be regarded as persons aggrieved by the impugned order, having accepted the same and acted in accordance therewith, WA number so and so is dismissed. So the premise on which the division bench dismissed the writ appeal, my lord, was that you have acted in terms of you have accepted the order of the Justice Sen, my lord, and you have filed a money suit. So we cannot file money suit also accepting the learned single judge's order and also file a writ appeal. So this does not impinge on our money suit in any way, my lord. The division bench only said, since you have accepted that order, you have gone and filed a money suit, how come you can again file an appeal? So in my humble submission, this order has no effect on the money suit, on the merit of the money suit, my lord. So my lord, in terms of the order of the Justice and learned single judge of this honorable court, we filed a money suit, my lord. They filed an application for rejection of plaint under Order 7, Rule 11, my lord. That is at page 89. I'll just refer to that, my lord.
Yes.
So, my lord, kindly see the cause title, man. An application praying for rejection of the plaint under mandates of Order 7, Rule 11 of the Code of Civil Procedure. We filed a money suit, they filed this application, my lord, for rejection of plaint. Now, an order came to be passed in this Order 7, Rule 11, my lord, to page 103. Page 103 is the impugned order, my lord. The order passed by the learned assistant to DC rejecting our plaint, my lord. Saying, now, what the learned court below has said, my lord, I'll just read one para only, my lord, 108, at page 108. Just concluding part, my lord, read. Hence, in view of the above foregoing observations made by this court with regard to the absence of a cause of action and non-joinder of necessary parties as provided in under the proviso to Order 1, Rule 9 of the CPC, this court is of the considered opinion that this instant suit is not maintainable in its present form for non-joinder of necessary parties as provided under the proviso to Order 1, Rule 9 of the CPC for want of a cause of action and for being barred by law as provided on Clause A, D under Order 7, Rule 11 of the CPC, which is reproduced here under so and so as a quoted matter. With the above observation, the application filed with the dependent under Order 7, Rule 11 is allowed and the plaint is hereby rejected and the matter stands disposed of. Now, my lord, against this order, because this has rejected our plaint, my lord, so the only remedy available to us against this is to file an appeal, my lord. So we filed an appeal before the appellate court, which is the court of the Deputy Commissioner, my lord. The appeal is at page 154, along with an application for continuation of delay of 707 days. The sole issue, the core issue of your lordship is whether the learned appellate court below was right or not right in condoning the delay of 707 days, my lord. Because I'll not take your lordship to the merit of the appeal, because that is ultimately to be decided by the district judge. If we come on second appeal, maybe things is different. But as on now, the only issue is condonation of 707 days. Now, my lord, the grounds which they have taken, what I understand, my lord, the primarily 3 grounds they have taken, my lord, before lordship. First, they are saying that there is no mention of provision. I'll just take your lordship to our application, my lord, the condonation application which you filed at page 154, my lord.
Yes.
My lord, cause title, we simply said, my lord, an application for condonation of delay of 707 days in preferring the instant appeal against the order dated so and so passed by. So we did not make any mention of under which provision we are filing, my lord. Now the question is whether this is fatal to our application, my lord. Whether mentioning or non-mentioning, or whether mentioning of a wrong provision will affect the jurisdiction of the Honorable Court, my lord. Now, the learned court, we placed a judgment of the Supreme Court, my lord, before the learned court below, and as we referred, I'll refer to that, my lord. The Supreme Court has clearly said that as long as there is a power with the court, the court has the jurisdiction and power, my lord, whether in an application the provision has been mentioned, not mentioned, or wrongly mentioned, that will not affect the jurisdiction and power of the court. And even if it is not mentioned, the court has the power to deal with the matter as long as it is within the competence and jurisdiction of the court, my lord. Just take up, please. (2009) volume 12. I'll give a compilation also.
I think this was referred in that.
Is recorded in the order also.
Sorry,
Mr. Kanta has referred to that.
My lord. 2009 volume 12, page 175, my lord. Para 18, my lord. 18.
Yes.
I'll just read one para only. It is also now a well-settled principle of law that mentioning of a wrong provision or non-mentioning of any provision of law would by itself be not sufficient to take away the jurisdiction of a court if it is otherwise vested in law. While exercising its power, the court will merely consider whether it has the source to exercise its power or not. The court will not apply the beneficent provisions like Section 5 and 14 of the Limitation Act in a pedantic manner when the provisions are meant to apply and in fact found to be applicable to the facts and circumstances of the case. In our opinion, there is no reason as to why the court will refuse to apply the same only because a wrong provision has been mentioned. In a case of this nature, subsection 2 of Section 14 of the Limitation Act per se may not be applicable, but as indicated herein above, the principle thereof would be applicable for the purpose of continuation of delay in terms of. So the latter portion is not, but with the principle, my lord, enunciated by this Honorable Supreme Court, that mentioning, not mentioning, or mentioning a wrong provision will not affect the. And this was a case under Limitation Act, my lord. So that is my answer to that particular part, my lord, where they are saying that no provision was mentioned, my lord. This is the first ground they have taken. Second ground they have taken is that there is no power to condone delay beyond 30 days because this is under the special statute. Now, my lord, even this has been dealt. We placed the decision of this Honorable Court, my lord, a full bench decision rendered in Selection Committee, where this Honorable Court held that Limitation Act is applicable to the entire state of Meghalaya. I'll place this.
Reported.
My lord, reported one. I'll try to find, my lord. No, this is Justice Sen, Justice Vash, and Chief Justice Maheshwari.
What is that?
Selection.
What was that?
Review petition.
Yes, my lord. This was first in review. I'll just refer to the last page, my lord. Only one or two. One. Just last page, my lord. Operative part. The very last page, my lord. Conclusion, my lord.
Yes.
It says, my lord, in view of the above, the answer to the referred questions are as under. Para 1 is important for us, my lord. The Limitation Act 1963 applies to the entire state of Meghalaya, including the tribal areas or autonomous districts or regions. Other parts are notable. This is a very authoritative pronouncement by this Honorable Court, full bench, my lord, that Limitation Act is now fully applicable to the entire state of Meghalaya, my lord. So once Limitation Act is applicable, my lord, Section 5 of Limitation Act will also be applicable, my lord. It cannot be that Limitation Act only some portion, if the entire Act is applicable. So Section 5 will also be applicable, my lord. And the benefit of Section 5 is available to the state government, my lord, in this case. So this is my answer to, my lord, the second primary ground raised by them. The delay cannot be condoned beyond 30 days. Yes, my lord, to say that this is a special law and that is a general law, so special law will apply, general law will not apply, my lord. Now there is a very clear pronouncement that Limitation Act as such is applicable, my lord. So that dichotomy, that special law, general law is not available to us to argue in the state of Meghalaya anymore, my lord. The Limitation Act is in full force in the state of Meghalaya, my lord. So that's my answer to second issue, my lord. My lord, I'll only refer to the rules are there. 1937 rules. 1937 rules are there. Administration of Justice rules.
Yes.
Well, I'll refer to Rule 41, my lord.
Yes. Rule 41.
41.
Yes.
It says, my lord, application of Limitation Act.
Yes.
Although the Indian Limitation Act 1908 has been barred by notification number so and so dated 8 September 1934, the principle of the act should be closely followed in disputes between persons not belonging to a scheduled tribe or tribes specified in items 1 and 2 of Part 1 of Assam of the Schedule to the Constitution. So the provision as existed, my lord, Limitation Act is not applicable in the state of Meghalaya by the notification, my lord. But still, if the dispute is between tribals, my lord, Limitation Act should be followed. Now, a full bench decision of this court comes, my lord, and that full bench decision will overrule the provisions of Section 41, my lord. All these provisions were considered by this honorable court, and a very authoritative order has been given that entire Limitation Act is applicable in the entire state of Meghalaya. So, my lord, the provisions of Section 41 or 36A to that extent that appeal has to be filed within 30 days only have become redundant, my lord, and the judicial pronouncement by this honorable court will prevail over these notifications and rules, my lord. That's my submission, my lord, with regard to 30 days. But otherwise also, my lord, a provision, my lord, that no appeal can be filed beyond 30 days is unreasonable, my lord. Because lordship has seen there is a recent legislative trend that is now what the parliament has done in some of the legislation, especially in Arbitration Act, even in this new Land Acquisition Act, my lord, the period of limitation is prescribed, my lord, 90 days, for example, then condonable only by 60 days. So, but beyond 150 days, no condonation. There is no provision. But Arbitration Conciliation and New Land Acquisition Act also similar provision is there, my lord.
Yes.
So, my lord, but to say that there will be no provision for condonation at all, you can restrict the condonation, my lord, no condonation beyond 1 year or beyond 6 months or maybe beyond 30 days also. But there has to be some provision for condonation, because otherwise the judicial system will not function.
But what is the remedy now?
If there is no condonation beyond 30 days, my lord, there is no remedy. That means, and that cannot be, my lord.
Now you are saying that this is the situation now.
My lord.
There are some acts which has inserted this provision of fixing period
Minimum and maximum condonation period.
Now beyond that, like you said, because of whatever reason that you have, appeal or application could not be filed beyond
Yes, ma'am. Cannot be filed, my lord.
within that period.
My lord.
But still you have to file it. So what is the remedy then?
But once under Arbitration Act, once crossed 90 days, my lord,
Yes.
then we have to file delay condonation application. But that also only for next 60 days, my lord. if we delay beyond that also, it's gone, my lord. There's no remedy available to that. Maybe 227, my lord.
The rule 36A speaks of the same thing.
But 36A doesn't give outer limit, my lord.
It says beyond 30 days.
But it doesn't say that 30 days first limitation, but can be condoned by another 30 days, my lord, and not beyond that. It doesn't say. Like what Arbitration Act says or Land Acquisition Act says.
There's no provision for condonation at all.
My lord.
We are not talking about the other aspect,
My lord.
where now you say that the Limitation Act is applicable
My lord.
by virtue of this court's order.
My lord.
That has to be examined.
My lord. So that is the second aspect, my lord. So these are the two technical objections.
We'll continue. Time is
DB time. Continue tomorrow or day after?
not tomorrow. Tomorrow we have DB. You suggested it.
Let it be on Monday, Your Lordship.
Next Monday. Thursday, Friday, not possible.
Monday. It's free for the court. Okay. Or if my colleague insists, let it be on Friday also.
Tuesday. We'll have it on Tuesday.
Next Tuesday.
We'll continue on Tuesday. Heard Mr. EGK Kantala, Senior Counsel, along with Ms. Counsel for the applicant, for the petitioner or applicant?
Petitioner.
Petitioner.
Revision petition 227.
Also heard Dr. Musika and Musika. You are special counsel here?
Yes.
Senior counsel and special counsel for the respondent along with Mr. Hearing is not concluded and will continue on a date fix. As agreed to by the parties, this is matter for further hearing on 29.
It will be 5th October, August, my lord.
Oh, 5th. Today we are?
Today is 29, my lord.
Sorry.
Today?
5th.
No, today is 29th, 5th August.
I'm still backward in time.
I'll become senile also.
Most probably. That is why you see, it's more in that in that respect, it is more important for the parties to make their cases very clear, so as to avoid confusion.
I avoid making extempore submission, Your Lordship.
True.
Obliged.
Okay, so 5th.
Item number 2.
What do we do? I think we don't have time also today. Also.
Wait.
We have to rise now.
Right, my lord.
Fixing we'll continue on Thursday.
My lordship, Thursday, my work takes me out of station. If you can kindly be fixed on Friday or tomorrow.
No, tomorrow we have DB.
Quite a few.
Friday? Friday.
My lord. Right.
As agreed to by the parties, this is matter for the hearing on 30 on 1st.
From daily list, item number 1.
My lord, this is rather a pressing and an issue of concern, my lord.
Mr.
I'll not take much time on it.
Mr. Khera, just a moment. I have read the petition. What is your prayer?
My lord, my prayer is to quash the proceedings.
Either you withdraw this petition or it will be dismissed. You have no case.
My lord, I will present the law on
You
it.
have no case, Mr. Have you read this Ramarao case?
No.
I have brought it here.
My lord.
You read this. P. Ramachandran Rao. This is 2002 for SEC
2002.
578. You have the case with you.
My lord, I'll go through the judgment. My lord, there are several pronouncements.
You read this. This is a constitution bench judgment. You read paragraph 20. In fact, I'll show it to you.
My lord, my sole case is resting on only one leg on the argument.
True. If I understand correctly, only for the delay in
My lord, the delay has infringed my fundamental right under Article 21.
This is a case, similar case as yours.
My lord.
CBI case. And that the delay there is 37 years.
37 years.
And
My lord.
Still High Court, Supreme Court says no.
So, but my lord, there has to be, I'll read the judgment, my lord. There has to be a path where they cannot go on prolonging it.
True. See, but it is not for the Superior Court to set time limits. It's very easy. That is very clear. In the Antuli case, that has been stated. Treated here.
My lord, Antuli case, the Supreme Court has come down very categorically. In fact, there they have gone on to say the proceeding should go on a daily basis.
True. Those, you see, all those things are there. But you cannot, you see, you cannot set time limits. That is very, you see, the Supreme Court is very emphatic as far as that. So, whatever the case may be, you see, you may have a case, I'm not saying,
My lord.
But not before this court. The trial court maybe. You have to impress on the trial court for.
My lord, there is an order which stands on the trial court's record also for a day-to-day trial, but nothing has progressed ahead.
On that ground, then you have to file a application, assailing that. Otherwise, and what else? You see, I think even this court is bound by the doctrines of precedent.
My lord, let this matter come up on Monday. I'll also try to impress upon my lord that if my fundamental rights are being violated, the prosecution does not have the right to make me.
Okay.
My lord.
You note down that case.
We have, my lord.
Question, your lordship rightly observed. Maybe some other directions can be, but question is.
Question.
My lord, I have.
Question on the point of delay.
My lord. No, my lord, I have also come under 226 in this petition. So, my lord will, and 227, my lord, for superintendent. So, my lord will have the jurisdiction to exercise, my lord, of the opinion that the trial has to progress in a speedy manner. See, my lord, sometimes they don't have a.
See, Mr. Hira,
my lord.
This is one of those rare times.
My lord.
The court has made its mind.
My lord.
So, it's up to you.
My lord, let it come up on Monday. I'll.
As prayed for by parties, by counsel by petitioner, list this matter on.
4th, my lord, Monday.
4th.
Oblige, my lord.
Item number 2.
I want to put on
Please, Lordship. Lordship, in this matter, we've just received a copy of the order which had come.
Copy of what?
On the matter had come earlier, Lordship, and on the previous date, this formal call had directed the petitioner to bring a record the previous order in the criminal petition, Lordship.
Oh, those
Lordship, we just received
the position of the witnesses.
Yes,
so I have given them today.
Lordship, if the matter can come up day after tomorrow, Lordship, on Thursday.
Thursday.
Item number 2 and 3.
Thursday, okay. Thursday is okay with you?
31st, Friday, your lordship, if it is possible.
On prayed made by the parties. This is matter on 31st. On 1st. Friday is 1st.
31st.
31st Thursday.
Oh, 31st. Oh, 31st. Then Thursday, yours. Thursday.
First is 31st Friday. Now you say 31st.
Oh, okay. My first.
This is matter on 31st.
Much obliged.
Item number 3.
3 also same.
3.
Connected, Lordship.
Item number 4.
I think 4, 5, 6 will fix
Lordships. Lordships, in this matter, we have today we filed a miscellaneous application, Lordship, seeking for amendment of the prayer in the writ petition, Lordship.
Let it come along with the
Lordship.
major petition, Your Lordship.
Lordship.
Let it come.
Let it come, Your Lordship.
Lordship, may I have it
As prayed for by list this matter 1 week.
after 1 week, Lordship?
This is matter to 1 week.
Highly obliged, Lordship.
Apply, Your Lordship.
Item number 5.
When do we have it?
My lord, what was convenient, my lord? Next week? When was convenient?
Friday, Lordship, if subject to
I think
Lordship
we
convenience.
may have quite a number of matters on Friday. 1 week.
1 week.
As prayed for by the parties, this is matter to 1 week.
Item number 6.
Same.
Lordship, this matter, it's only, hearing is complete. It's only for written submissions. We have filed. My friend has to file.
I've already filed on last occasion, Your Lordship.
You have filed.
Yeah, during the course of the day I filed.
I haven't got a copy. Anyways, I'll take a copy.
You have filed yours.
I filed.
Matter reserve.
Reserve.
Mr. General Counsel for the appellant has submitted that the written argument on behalf of the appellant has been filed. Mr. N. Chaudhary, General Counsel for the respondent, has also submitted that you are for whom? For all the respondents?
No, only one. Respondent.
How many respondents are there?
Two respondents.
The other
One
one?
expert.
One has got expertise.
Respondent number 1.
One, yes.
Mr. General Counsel for the respondent number 1 has also submitted that the written argument on behalf of the respondent has been filed. Accordingly, judgment is reserved.
Hello.